So our next panel is on international family law trends, which is going to be very interesting. We have a great combination of talent on the stage who can talk about these areas. Our group is going to be moderated by Ivonne Aguilera, who is a partner, a corporate M&A partner at the Hoyos y Aviles in Juarez. Obviously, she has a very active practice and is has led the opening of the office for the Hoyos firm in Juarez. She earned her JD from the Universidad Autónoma de Chihuahua in 1995 and a master's degree from the University of Texas at Austin, which of course makes her a great person, so I'm all there with her. She was in-house counsel at HSBC from 1994 through 1999, was a senior associate with Baker McKenzie from 2000 to 2013, and partner at S. Legal Rubio Villegas from 2013 to 2020. And as I mentioned, she focuses her practice on business law, mergers and acquisitions, and compliance. So to help us welcome Ivonne Aguilera.
Thank you, Charlie. Good morning, everyone. It's very nice to see you in person this year. My name is Aguilera. I'm the board secretary of the USMBA since 3 years ago, and I'm very happy here with the bar. We will continue our program with the panel International Family Law Trends with the participation of Laura Dale, Christopher Noel, and Ryan Coyle. Thank you so much for being here. We appreciate very much your contribution to this event. Let me introduce our panelist. Laura Dale, she is the managing partner of Laura Dale and Associates based here in Houston. Laura is board certified in family law by the Texas Board of Legal Specialization. Her practice is concentrated in the area of family law involving high conflict divorce, high net worth property division, both domestic and foreign, property valuation, custody cases, international child abduction, and complex multi-jurisdictional family law disputes. Thank you, Laura. Christopher Noel, he is an attorney at Sequor Law in Miami, Florida. His practice focuses on international commercial litigation and appeals. He has experience recovering assets for clients in post-divorce settings in the Americas, Europe, Asia, and the Middle East. Christopher's advice includes best practices to consider before, during, and after a divorce proceeding involving high and ultra-high net worth spouses, with a particular focus on asset recovery procedures to maximize post-judgment recovery. Thank you, Christopher. And Brian Coyle, he's a lawyer at McDermott, Coyle, and Emery. They have offices in Miami, here in Houston, and Dallas. He focuses his practice on international tax matters with an emphasis on providing tax-efficient restructuring solutions for high net worth international families and their closely held business. Welcome, everyone, and we will leave 5 minutes at the end of the presentation for questions or comments from the audience. Well, given that the three of you are involved in divorce cases, and I will start with Laura, so you can tell us how do you decide where to file a divorce where there's more than one option to do it?
So this is a threshold question when you're looking, or you have a case where you have the possibility to file a divorce case in more than one jurisdiction. It's a really important question to look at and answer before filing anything. Filing, and the reason being is that your client may be able to file, for example, in Texas or Mexico or the UK, and the treatment of property division and child-related issues can be very, very different in each of those jurisdictions. So for example, let's see, if you have a large estate and your client has a lot of separate property, you may not want to file in the UK. I'm not sure exactly what.
Let's turn off your mic and use one of these.
Okay.
Sorry.
That's all right.
You know, it wouldn't be a legal conference without technical issues.
No problem. Does that work better? Okay. So you might not want to file in the UK if your client has substantial separate property assets, because in the UK, there is no separate property. It all goes into a community property bucket and is divided by the court. So that error in filing may cost your client a substantial amount of money if his or her separate property assets are not recognized in the jurisdiction. So when we have cases where it's possible to file in more than one jurisdiction, we look at those jurisdictions and how they treat property issues and kid-related issues to try and maximize the benefit that for our client. And I think it's really important in those cases to consult with foreign counsel, so you can make sure that you're making the right selection for your client, and that you don't end up with an unhappy client and possibly a malpractice suit because you could have avoided something catastrophic.
Thank you, Laura. And Ryan, could you please discuss the main difference between Mexican and US marital laws as it relates to asset management and property?
Sure. So I think that the first thing that I would say, and I think all three of us up here as U.S. trained lawyers would say, is that we'll always be consulting with Mexican attorneys when we're dealing with Mexican marital law. But of course, we pick up some of these factors via osmosis, having worked with a number of Mexican clients and clients from other civil law jurisdictions like Mexico. So one difference, and one big difference, I think we'll get a little bit onto marital agreements later on, but in Mexico and in many civil law jurisdictions throughout the world, in particular in Latin America, when a couple is married, they file a marriage certificate before a notary and can check a box selecting a certain marital regime, whether it's complete communion of assets, a partial communion of assets, or separation of assets. And each jurisdiction has sort of variations on those themes. But in other words, it's very simple compared to the US procedure in order to achieve certain goals that spouses might have when they're entering a marriage. In contrast, in the US, it's not quite as simple. There's no sort of box you check when you file your wedding certificate, your marriage certificate. And so it can be advisable for certain clients to prepare, we may have heard about prenups or premarital agreements or post-marital agreements to achieve certain goals, to sort of manage assets, debts, alimony, life insurance, other issues that the spouses may sort of want to go into the marriage having already agreed to. That's where a prenuptial agreement can come into play. One other thing I would say is that when working with clients, really moving in both directions. So, say a Mexican client moving to the United States, or I should say a Mexican married couple moving to the United States, or a US married couple moving to Mexico, it's unlikely that either Mexico will respect the US prenup, and I think you'll be talking a little bit later about this, but whether the US will respect the foreign agreement. I can speak anecdotally in the case of Florida that these foreign marriage certificates where you check the box for the marital regime are almost never respected in Florida for purposes of protecting assets that are brought into marriage. So I think we'll get into that topic a little bit more deeply.
Okay, thank you. And Christopher, what are some current trends regarding the asset recovery in matrimonial cases?
Sure. First, I just want to preface what I'm saying versus what Ryan is saying, because it is not always the case that a spouse hides assets or fails to fully disclose, significant assets during the pendency of a divorce. But I did some quick research before this morning's panel, and one of the biggest trends is that the wealthy are getting wealthier as the years go on. So as of 2020, there are 650,000 millionaires in the state of Texas. There are 56 billionaires in the state of Texas. There are 260,000 millionaires in Mexico and 13 billionaires in Mexico. So this is an issue that isn't isolated, but again, not super frequent amongst divorces. With that context, there are three main trends that we're seeing in the past couple of years, kind of during the COVID period. Many jurisdictions are recognizing that they're becoming hotbeds for asset shielding and asset hiding. Anecdotally, I have a case right now where a debtor coming out of a dissolution in London originally went to Vienna to try and hide his assets. The Austrians were not happy about that, so he transferred a significant amount of the wealth that's owed to the former wife to Dubai. And surprisingly, in the Emirates, especially in some of the free port zones, the Emirati courts are recognizing a former wife's claim to assets, which is not something that has traditionally happened. The other big topic is crypto. We've seen in the past year and a half a huge growth in crypto assets. I'm sure many of the people in this room have crypto assets to some level. Major banks are advising their high net worth and ultra high net worth clients to keep, I think the last time I checked, 3% of their investable assets in crypto as a hedge against currency inflation and equities issues. And crypto is very easy to hide. You go on an exchange, you buy the asset, whether it be Bitcoin or Ethereum or any of the lesser common cryptos, and you can hide it on what's called a cold wallet, which is effectively a USB thumb drive. So you download the crypto asset, it's not connected to the internet, it's easily transportable across borders, and it's very difficult to find, and even in circumstances where you do find it, for instance, if the other spouse is aware that there are crypto assets, you need passwords and other login information that is equally difficult to find if it's trying to be concealed. And then the final current trend that we're seeing a lot of, it touches on something that Laura said about jurisdiction, is that we see people filing for divorce in jurisdictions that are different than where they were married. So, a couple could be married in the United Kingdom, file in New York or in Miami, have the courts in New York and Miami strategically hear the case because their counsel advised them that there would be a beneficial position for them in those circumstances, or in a more nefarious position, we've seen people go and get effectively fraudulent divorces in jurisdictions where they have more corrupt legal systems or more influence on the judiciary. So in the same case with the family from London that my firm is working on right now, the husband obtained a false divorce decree from Israel that we've had to defend against in every jurisdiction that we've tried to protect our assets in. And that just adds an extra layer and more significant cost. And in those circumstances, there usually is a disadvantage for the spouse who's searching for assets. Typically, they don't have the same level of knowledge of the family's finances, and even if they do, they don't have the same level of access. So these are really barriers to entry that come up when a spouse has been disadvantaged in a divorce, and they, typically it's the former wife, believe that assets have either been hidden or there hasn't been full and frank disclosure during the dissolution proceeding.
Thank you. And Laura, how about Texas court? How do they decide about division of foreign assets and like retirement benefits or other assets?
Before I get to that, I wanted to say just one quick thing about something Ryan just said about prenups in Texas. So we have a little different approach in Texas. I usually tell my clients, Texas never saw a prenup that it didn't like. Texas law favors prenups and marital agreements. We love to enforce them. It's very, very difficult to overturn them. I think in my career, I've only achieved that one time. Recently, we have a case out of the El Paso Court of Appeals where the El Paso court overruled the trial court and upheld a check-the-box a separate property regime election. And that's not the first court in Texas to do that. There was a case in 1995 out of the 14th Court of Appeal where a Texas court upheld a check-the-box separate property regime election. And that's important because obviously there are a lot of countries where this election is possible and it's done just as part of the marriage certificate. It's generally an election that's enforceable in the foreign country. And the El Paso court in 2020 found that they were going to enforce that selection or election in a Mexican prenup separate property regime election. So I'm optimistic for my clients who have entered into these agreements that they're going to be enforced by Texas courts and saying, well, I think they'll be highly likely to be enforced by Texas courts if they're made in foreign countries. As far as property division, Texas, I think one of the other issues you have to look at about how Texas can divide property, whether it's in Texas or outside the state or the country, you're going to have to look at, again, the jurisdictional question of, does Texas have jurisdiction to divide property? There's generally 3 jurisdiction buckets that we look at in divorce cases. One is the ability for Texas to grant a divorce, a status divorce. All it needs is personal jurisdiction to do that. Texas can also divide property if it has personal jurisdiction over the parties, and can't necessarily divide a piece of real estate in Mexico, but it has the authority over the individual to order the individual to do certain things like sign documents to transfer title and things like that. You may run into enforceability issues on cases like that. For example, I know in France, the French courts will not generally enforce an order to transfer real estate that's in another party's name, even if there is a Texas court order, because of very complex property rights laws and tenant laws in France. That may be an issue in Mexico as well. So generally speaking, in cases where I have foreign assets or foreign property, I'm looking to offset the value of those assets with property in the United States that the U.S. courts have more control over. If it's not possible, then I think you need to consult with foreign counsel to find out if you can divide the property, or if Mexico, for example, would enforce a Texas decree dividing property. What's the magic language that needs to be in the Texas divorce decree to cause a Mexican court to recognize a Texas property division order? So it can be complex. I recommend working with foreign counsel to achieve that goal way in advance of your trial date or your settlement date. You've got to know, can you divide those assets, and will the foreign jurisdiction enforce the division order?
Just to add to what Laura just said, it's critical that if you have assets in multiple jurisdictions that you bring in foreign counsel prior to any final order, because it is so inefficient and so time consuming to have to go back in front of a court and risky and have them amend an order that contains findings or sanctions or things that jurisdictions around the world don't recognize or would reject the final judgment as a whole because of. So it's just another reason to bring in competent foreign counsel as early as possible.
Thank you. Is this an issue that you recommend to include in a prenup agreement? the division of assets in case of divorce? Is that possible? Or?
To include, I mean, anything is possible almost in a Texas prenup agreement or marital agreement. But if you're going to talk about specific property, yes, it's absolutely possible to set out the terms for division in a premarital agreement with regard to specific properties. We usually do that on schedules that are attached to the premarital agreement. I think one of the critical things, probably the most critical thing when you're counseling a client with regard to a premarital agreement is the election of law clause. So that is a subject that you need to spend time talking to your client about. And what that means is, what law do you want to apply? So if you primarily have assets located in Mexico, companies, businesses, things that are going to be complex to defend or divide, or whatever the legal issues you're going to get involved in, you may want to say in a prenup that Mexican law is going to apply to the division. So you can do that under Texas law. You can contract and select the jurisdiction where you want, or the law that you want to apply. So it's important to talk about that, and that election needs to have some connection to the parties. I mean, you can't just say, I want to apply French law, but neither party has a connection to France and you don't have any property there. So it has to have a reasonable connection to the parties or the property, but you can select that option in advance, and you should. I cringe when I see prenup agreements that don't have election of law clause, because then I'm going to have to figure out, under Texas law, is foreign law going to apply or is Texas law going to apply? And that's a complicated analysis to figure out what kind of law is going to apply. And it may be particularly complicated for the judge if they don't have any experience or know how to or have experience making that decision, which is not very common.
Just picking up on the theme of bringing in competent local counsel as soon as possible, or as soon as you realize it may be necessary, you may need them even before you realize it's necessary. As I learned from a recent case in Brazil, there was a US person who moved to Brazil and founded a fintech company, and in the early days of the fintech company, had a girlfriend and moved in with the girlfriend, were not married, had no sort of formal agreement. But in Brazil and in many jurisdictions, generally not the US, I don't think, but certainly in Brazil, merely living together can create certain property rights in both of the spouses. And of course, our client didn't know this. I don't think he even had Brazilian counsel at the time. And so his company is going public, and so we're advising on some pre-IPO planning, and of course in consultation with Brazilian counsel, and one of the family law lawyers in Brazil said, oh, so when you getting married? He said, oh, we're getting married in a few months, we need to start thinking about prenups or whatever it is that Brazil requires. And the Brazilian family law attorney said, well, you've been living together for 4 or 5 years, during which most of the appreciation in the founder's company has occurred. So technically, that already belongs, half of this company, or half of your interest in this company already belongs to your girlfriend, not your wife, but your girlfriend. And what was challenging here, even in the best case scenario, the girlfriend was super understanding and of course wasn't trying to take advantage. The relationship is in a great state at the moment, so she said, fine, I can just disclaim my interest under Brazilian law in your half of this company that you founded. And so that's great, so go back to Brazilian lawyer, and unfortunately, there's no concept under Brazilian law like in the US where spouses are able to make unlimited gifts to each other without any sort of imposition of gift tax. In Brazil, that doesn't exist, at least for this purpose. So if she wanted to disclaim her half interest in this company, it would be subject to Brazilian gift tax, as if she gifted this interest to the company. So there are a lot of ways to work around this challenging issue, but just to say, one, bring in competent local counsel as soon as possible, and two, sometimes you may not even be aware that you need to bring them in, and I think these, the concept of a civil partnership, or in Brazil they call it an união estável, or maybe a similar concept in Mexico, just be careful because property rights can accrue even before marriage.
Okay.
And what, and what happens, Christopher, when one of the spouses is hiding assets or not disclosing ownership of assets? What do you recommend your clients to do, or what tools do you have available to try to trace?
Sure, so obviously, just as a marketing pitch, I would recommend anybody who has clients who think that a spouse during a dissolution is hiding assets or not providing full disclosure, call somebody who specializes in asset recovery, has experience in marital asset recovery. But the earlier, much like Ryan just said, the earlier the better in our experience. Typically, we can be brought on as limited consulting or investigatory counsel at the onset or before filing of the divorce proceeding, so that we can frame the discovery in a way that will allow us to get an idea of where the assets may be. Another recommendation, to the extent that it's legal in whichever jurisdiction your clients are in, is for the spouse to collect whatever records are available. Typically, people do receive bank statements at the house. The spouse may not be the primary financial person in the relationship, but if they can just collect those documents, just knowing what banks, what financial institutions the family uses is really invaluable, and that saves a lot of time on the back end. Or obviously, asset recovery counsel can be retained after judgment. It's a little bit more difficult of a process then because discovery is more limited. But there are discovery tools available in the United States that many family lawyers, especially international family lawyers, may not be aware of. There's Chapter 1782, which is a federal statute that allows a federal court in the United States to issue discovery in assistance of either a contemplated or ongoing foreign proceeding. And contemplated is key there because we can get access to banks in the US and have officials from those banks sit for deposition before a foreign dissolution action is even filed. So we can get a great idea of where the assets are, what the assets are before filing, which allows the petition for divorce to be framed in a way that informs the judge from the onset that there's something going on that is improper. Chapter 15 of the Bankruptcy Code also allows a similar process. Chapter 15 allows a US bankruptcy court, a federal bankruptcy court, to recognize a foreign main proceeding, and then it gives the participants to that proceeding in the US access to federal discovery, which is, again, something that in many civil law jurisdictions doesn't exist. And, civil lawyers typically are concerned with these processes because these are tools that they don't typically have available to them. And you can apostille any of these documents, any of these depositions. You can go through the formal process, and they can be introduced in a civil law proceeding. And then outside of the United States, in any Commonwealth jurisdiction, so that's the United Kingdom, all of the Isles of the United Kingdom, the British Virgin Islands, Hong Kong, those jurisdictions, there's something called a Norwich Farmable Order that's available. And that's kind of an analogous proceeding where it's typically done ex parte without notice to the debtor. And it allows you to go in these asset protection hotspots and get information and discovery from banks and different financial institutions that have their hand in shielding the assets. And typically it's a fairly easy process. The registered agents of offshore companies that are really shell companies don't put up too much of a fight. It's their reputation on the line, so they typically will just comply, provide whatever information you're seeking. And if you can get a guidance seal from one of these Commonwealth judges, the ultimate beneficial owner of the company or the account may not ever even find out that you've obtained the information that you can then use in a divorce proceeding.
And Christopher, are there any favored jurisdictions that you can mention in particular for this purpose, to hide assets?
Sure, yeah, they're the typical ones that came in Switzerland, Liechtenstein is a very popular destination. It's very difficult to practice in, to get information. Liechtenstein's a municipality. The banks are owned by the royal family, as are effectively the courts. So you're petitioning a court to disclose information about something that they shouldn't have been doing. But there are jurisdictions in the Americas that are relevant. Venezuela is a very difficult jurisdiction that has not the most above board judicial system. And it does allow the shielding of assets there. And I mentioned, Dubai in the Middle East. That seems to be the new hotspot for international billionaires and multimillionaires to hide their assets because of their friendly free port system. And then again in the Americas, there's Panama, the British Virgin Islands. I think I read recently that something like 85% of the world's wealth travels through the British Virgin Islands at some point. So there are the usual suspects, and then the Middle East is becoming a more favored location.
Okay, thank you. And moving to another topic in family law, Laura, can you tell us where can you file a custody case?
Yes, so custody is another basket, a jurisdictional basket that we look at. So it's very possible for Texas to have jurisdiction over the possibility to grant a divorce and divide property, but Texas may not have jurisdiction over the children if the children haven't met the requirements under what we call the UCCJEA, which is a uniform code that helps us determine in the United States. All states have enacted it except one state, where jurisdiction lies for children. So it's highly possible that Texas may believe that it has jurisdiction and may actually have jurisdiction over children, but other countries under their own laws may determine that they have jurisdiction as well. And so you can get into conflicts about custody and which country has jurisdiction. So again, before you file the case, you need to determine those issues that Texas may or may not have jurisdiction over, and what are your options for filing? Where should you file? Are there other countries that have more favorable laws related to your client when it comes to custody? For example, Japan basically awards custody to women. So does Russia. In Texas, that would be unconstitutional, a violation of constitutional rights to award custody based on gender. Certainly in Texas it would be. So again, you're going to have to look at if you have child-related issues in a case and you're going to file a divorce, you need to consider those issues, where you want to file, what the laws are in the various jurisdictions. Again, you want to consult with foreign counsel to see how that issue may impact your case. And, obviously, who gets the kids can sometimes impact property division in Texas. Property can be divided disproportionately in favor of a parent who is awarded custody. There's also the issue of spousal support, which is a hot topic in international family law cases, because there are now international treaties under the Hague Convention related to spousal maintenance and how that issue is decided and which country has the right to decide. So again, it's as the world becomes more globalized, I guess, and populations are moving frequently, these issues can become very complex very quickly.
Thank you. I think we are having 5 minutes in case someone has questions or comments.
Yeah, I think we have, just to be sure on this, we have until 11 o'clock, so you have about 5 minutes worth of questions and answers.
There is a question.
It's just a brief question. Well, hopefully I have a brief answer because it's a hard topic for me. So, where's the line between a personal issue and a form selection issue?
By
Or
that,
form shopping, sorry.
okay. So, I don't think you're gonna, I'm trying, I want to make sure I understand your question, but I'm not concerned about a forum shopping concern unless the jurisdiction that I'm trying to argue is questionable. Or, there's obviously a forum shopping issue. I mean, most of the cases I'm talking about, there's clear, unquestionable jurisdiction on issues, whether it's child-related issues. It's hard to forum shop that from a Texas court point of view. We either have jurisdiction or we don't. The court can relinquish jurisdiction, but I think when you're arguing jurisdiction, you're gonna have to have fairly favorable arguments. And foreign shopping cases where that's a problem, usually one party has very dirty hands. They've abducted a child, or they've done something that's going to raise the suspicion of the court, and it's usually pretty easy to make a foreign shopping argument because of bad behavior of one of the parties.
Thank you.
Okay, my question is kind of, okay, my question is kind of related to what Grace just asked. So what happens when there's, let's say a divorce proceeding going on, or maybe it's not finalized, the couple is still separated, and one of the spouses abducts, the word you just used, abducts the children or a child and takes them cross-border. So let's say they were married in one jurisdiction, but they take them to another country, in this case, Mexico, Texas, for example. What would the procedure be there? Like, how, I don't know if this is an abduction that it is tried in Mexico, if it's tried in Texas courts, and how is that, if they eventually do that divorce, how is that handled or decided ultimately between both jurisdictions?
Okay, really good question. So between Texas and Mexico, or the United States and Mexico, both countries are parties to the Hague Convention for the Prevention of International Child Abduction. So when there is an abduction, and each case has to be looked at, they're fact specific, and in order to have an abduction, there's certain elements that have to be present. But let's assume for a moment a parent abducts a child from Mexico to the United States. Under the Hague Convention, that case can be brought either in federal court or state court. We usually bring them in federal court. The case is filed in the jurisdiction where the child is brought to. So that if the child is brought to Texas, to Harris County, we file the case in federal court. The parent, the left behind parent in Mexico, starts the case by filing an application with the Mexican Central Authority, telling the Central Authority that their child has been abducted. It's a form that can be filled out online with the Mexican Central Authority. They usually ask for statements relating to the facts regarding the abduction and certain documents to prove that the child was residing in Mexico before the child was abducted. That application is sent to the U.S. Central Authority in Washington, D.C., and that authority usually contacts a Hague lawyer, somebody who's working in the area. Our firm works with the State Department all the time, and we bring a case on behalf of the left behind parent. And the reverse, if a child is abducted from the United States to Mexico, then the case is filed in Mexico. The left behind parent in the United States files an application with the U.S. Central Authority and the State Department, and the U.S. State Department transmits that request to the Mexican Central Authority, and then the Mexican court hears that case. So it's a very structured process. It's designed to be a short process. Generally speaking, these cases should be tried within 6 weeks. So you really have to be prepared to, and ready to try the case in 6 weeks. We're happy to help. It's not an easy thing to do because it's a very structured procedure, but there's a network of lawyers out there that are willing to help people who represent individuals whose children have been affected. And you can go to the US State Department to find out more about that.
By Mexican Central Authority, you mean the Board of Claims Service? SRE?
No, so each country under the Hague Convention designates what is called the central authority. In the United States, it's the US State Department. In Mexico, I'm not exactly sure.
Typically, the Americas. Yeah, it's within the Ministry of Foreign Affairs. Or in other countries, it could be within the Ministry of Justice, depending on the organization.
Okay, I think in Mexico is Foreign Trade Service. SRE.
Yeah. So then both the departments are communicating with each other about the case.
I had one last question that I think kind of transitions into our next panel, which is on diversity. A lot of young people, this new generation is not so tied to people relationships, the polyamorous relationships, talking about what happens to that poor man that lived for 4 years with his girlfriend in Brazil and then suddenly found out she don't have his company. Has there been any litigation yet dealing with those types of situations where you've got more than 2 people cohabitating, and how does that play out?
So with regard to the Brazilian couple, US Brazilian couple, there's not clear case law in Brazil, and because there's not a clear case law there, there's certain structuring that we were doing to try to both not have to pay the gift tax and for her have to be deemed separate property owned by the founder. So I can just speak for Brazil, kind of as a US lawyer, to say that unfortunately the law is not clear there, and that's why there's a little bit of gray area for some planning to be done. On the US side, I don't know if you have any thoughts.
There was, right before I left Miami 2 days ago, there was an article in the news that there are cases being brought specifically about polyamorous relationships, but I don't think that there's any developed case law in the state of Florida on that topic at this point.
In Texas, we are one of the few states that has, we have a common law marriage. And so you can get snagged up in a informal marriage, is what we call it under Texas law. And it's not quite as shockingly simple as in Brazil. It's mainly a 3-legged stool. You have to have cohabitation, an agreement to be married, and holding out as married, and then you might likely be found to be married under Texas law.
So thank you very much to our panel for that great presentation. I've got some certificates here.